I'm Drew Stevenson, and this is a video for my professional responsibility class about ABA Model Rule 1.2 D. And so this is part 3 of my video lecture series about Rule 1.2, which is about the scope of the representation and the allocation of authority between a client and the lawyer. And in this video, we're really talking about client crime and fraud. In other words, what is a lawyer supposed to do and what the client is really using the lawyer for is in some way to commit a crime or to commit fraud. So let's look at what the comments say. And the comments are going to remind you of what the rule is. That in 1.2D, it prohibits a lawyer from knowingly counseling or assisting a client to commit a crime or fraud. And so if you're asked about this, of course, you could also be criminally an accessory to the crime, but you would also be subject to discipline. So when the client isn't always right, in other words, and keep in mind that if a client is asking you to do something illegal, that doesn't excuse you. You can't excuse your behavior and say, well, I was just doing what the client told me to do. I'm just the lawyer or I'm just the messenger. Actually, if you know that your client is using you to commit a crime or fraud, you have to refuse to do that. Now, that doesn't preclude you as a lawyer from giving an honest opinion about the actual consequences that appear likely to result from a client's conduct. So if a client says, I'm thinking of doing this, and you say, well, that would be illegal, and they say, why? And then you explain, and then the client realizes that if they changed one aspect of their plan, that it would technically be legal, or it would technically be very hard to catch them. That's different. So the fact that a client takes your advice uses it in a course of action and then they go and commit crime or fraud without you knowing it, does not make you a party to the course of action. So a client may come to you and say, okay, explain something like money laundering or how this works, or what do the law enforcement officials say? And you explain it and explain the elements a prosecutor would have to prove and what evidence they need to prove different things. And then your client is clever enough to take that and figure out how to commit a perfect crime. That's not your fault. So comment 9 to Rule 1.2 says there's a critical distinction between representing or presenting an analysis of legal aspects of questionable conduct and actually recommending the means by which a crime or fraud might be committed with impunity. So if you're telling the client, by the way, make sure you shred the documents or discard the murder weapon or dispose of the body or something like that, at that point, you're kind of coaching them in how to commit a crime. You're not allowed to do that. But if you are allowed to give them a legal analysis of, say, look, this makes it illegal and this doesn't, and so forth, and now the client is able to kind of take that and navigate it on their own to commit a crime or fraud, that's different. And admittedly, that's a fine line sometimes between the two. But for test questions, you need to recognize that those are two different things. You're always required to avoid assisting a client in drafting or delivering documents that you know are fraudulent, or suggesting how a wrongdoing could be concealed, for example. And now let's say that originally when you started representing the client, you thought what they were doing was fine. I hear this story sometimes from lawyers who represented people who were running a Ponzi scheme, right? So the person who was running the Ponzi scheme lied to their lawyer. So even their lawyer was kind of fooled and didn't understand exactly what was going on for a while. But at the point when you do catch on, then you have a problem and you're going to have to withdraw from the representation. So you may not continue assisting a client in conduct, even if you originally thought or supposed that it was legally proper. Once you discover it's criminal or fraudulent, you are going to have to drop out from the representation in the matter. And sometimes even that's not enough, right? It's not enough to just say, no more of this, and now I know what you're really doing. Sometimes you have to do something we call the noisy withdrawal. In other words, this means giving notice of the fact of the withdrawal to other parties and disaffirming any opinion, document, affirmation, or the like. And if I can give an example, a couple of quick examples to my students, let's say a client has had you draft some opinions about their business and do sort of an audit of their liabilities. to submit to a commercial lender or a group of investors, private investors, who are either going to lend to the money to the client's business, or invest, or it could be a government agency. And then what you realize after a while is that you had relied on the numbers about the client's, let's say, income, revenues, and losses. And now you know that the client was giving you false information and that you've been passing along fraudulent numbers to other parties. Well, it's probably not enough for you in that case merely to withdraw from the representation. Probably you need to notify the parties that you sent fraudulent representations to, or fraudulent applications and forms or legal opinions, and basically say, I hereby disaffirm those. Now, you may be wondering, why don't you just say my client was committing fraud and I'm putting you on notice? Well, technically, it's a question of whether you're allowed. It's a separate question, to betray the client's confidentiality. So in some cases, it may be enough for you merely to withdraw from the representation and tell the other side, I am no longer representing this client, and I hereby disavow and disaffirm anything I have represented up till now. Their lawyer is going to know what that means, but you haven't technically ratted out your client in that sense. Okay, so sometimes the noisy withdrawal is necessary. Comment 12 says, the paragraph D applies whether the defrauded party is a party to the transaction or not. And they give a specific example that this should be an easy test question. If you get it, it's always wrong. It's always a violation if you are helping a client commit tax fraud or fraudulent tax avoidance. And so now, if you're giving your client tax advice about how to take advantage of different corporate exemptions and deductions and exclusions and so forth, that's one thing if it's legal. But if you're telling your client how to hide assets in offshore bank accounts and not report things on their tax returns, you are basically helping them effectuate tax fraud. And so you will be subject to discipline for that, even if the prosecution can't prove that you were an accessory to the crime for purposes of conviction and of criminal charges. And that concludes our lectures about Model Rule 1.2.